Good afternoon, everyone, and welcome to the second session of the RTPI Enforcement Week. My name is Neill, Whittaker, and I'm the chair of the National Association for Planning Enforcement, or NAPE for short. And I will be chairing this afternoon's discussion session covering adverts and enforcement. We're going to be hearing from 4 panelists from all of the home nations who will each give a short presentation, following which we'll hold a discussion and Q&A session. So I would encourage all of the attendees. I can see there's about 130 of you, of you online at the moment, so that's great. So I'd encourage all of you to get involved with the session if you can, and you can do this by clicking on the questions tab on your screen and typing in your comment or question. So I can see it, and then hopefully I'll be able to pick up on these and relay them to the panelists during the discussion and question and answer session. And we'll do our best to get through as many as we can before 3 o'clock. So first of all, we're going to be hearing from Mike Hyde. Mike started his planning career in 1990 in the Lake District National Park, and has throughout his career has spent 15 years as an enforcement officer at Eden District Council. But in 2008, Mike established MH Planning Associations. And many of you, I'm sure, will recognise Mike, who is also an associate at Trevor Roberts, and has given many presentations on the topic of enforcement and the control of advertisements. So it gives me great pleasure to introduce Mike, who will be putting his presentation hopefully up on the screen now. And I'll leave it with Mike for the time being. Thanks, Mike.
Okay, let's go. Right, is that okay? Right, assuming that this is all working, as Neil said, I'm Mike Hyde. I'm now planning consultant at MH Planning Associates, based up just outside Glasgow in Scotland. But in my planning career, I've been a planning officer, planning enforcement officer, and also, as Neil said again, an associate at Trevor Roberts Associates, where I've done a lot of training over the years, and particularly training on advertisements and particularly advertisement enforcement. So these first couple of slides are just a couple of my kind of background training slides from the work that we used to do in Mattingly, just to get a bit of context as to why we have a regime that now allows us to control the display of advertisements. So going way back to the century before last, there was a chap called Mr. Richardson Evans, who in 1893 founded a society for checking the abuse of public advertising, or SCARPA, in order to focus opinion on the disfigurement caused by outdoor advertising. And through his work, he promoted the first degrees of advertisement control through the passing of the Advert Regulation Acts in 1907 and 1925. These were then followed up with the first Planning Act as we know it, and through that, the Control of Advertisements Regulations 1948, which brought advertisements for the first time under full control of the local planning authority. So given that SCARPA had done what they intended to do, they wound themselves up in 1953. Up here in Scotland, where I'm primarily based, our legislation is pretty much the same as yours. Certainly in terms of primary legislation, we have our Planning Act, the 1997 Act, that allows the Secretary of State to make regulations to control the display of adverts in the interest of amenity and public safety. And it also brings together the Planning Act and the advert regs in as much as if there's any development involved in the display of advertisements, like a flagpole or a hoarding, if the advert has consent, then there is a deemed planning permission granted for whatever operational development might be involved. We have a very similar definition of an advertisement to yourselves: any word, letter, model, sign, placard, board, notice, etc., used wholly or partly for the purposes of advertising, announcing, or directing. So we have a whole range of things that now come within the scope of the advertisement regs. And one of the things that I love after training people on adverts so much is that people still send me random pictures of adverts that they've come across or have been reported to them. And I've now built up quite an extensive library of advertisements for training purposes. So these are just some of the ones that we've come across over the years. They do get quite bizarre and sometimes a little bit controversial. So the first thing we always have to do is work out whether what is being displayed comes within that statutory definition of an advert. Our regs, I think our regs are probably the oldest in Scotland. They're still the 1984 regulations. Regulation 3 lists those types of adverts to which the regs don't apply, so enclosed land, moving vehicles, balloons, etc. We have our classes of deemed consent, the same as you do in the other regions, and any other adverts that don't benefit from deemed consent or are excluded require the express consent of the local planning authority. But the one thing we do have up in Scotland, which I think is unique to us, is we have an advertisement enforcement notice provided for under the advert regs that allows us to take straightforward enforcement action through the regs against unauthorised adverts as an alternative to prosecution. Similar to any other enforcement notice, it has to be served on the owner, lessee, occupier, any other person known to be displaying the advert, and must specify the advert displayed without consent, the steps that are necessary to restore the land or remedy the harm, and a time period for compliance. And again, as with a normal enforcement notice, it comes into effect within 28 days unless an appeal is lodged. Appeals are determined by the Scottish ministers, and the grounds of appeal are listed in A through to D. Again, very standard, but a great alternative to prosecution, which for us in Scotland is a bit of a nightmare because we can't summons people to the magistrates court. We have to go through the procurator fiscal, and the PF will very rarely ever allow an advert prosecution to proceed because they're just not perceived to be, in the overall scale of things, sufficiently in the public interest. So what I'm hoping we can get out of the debate is not so much the technicalities of which class of deemed consent might this particular advert fall into, but I'm quite keen to get an understanding as to why enforcement officers are doing less advertisement enforcement now than I think you are compared with when I was an enforcement officer, when about 10% of my caseload related to adverts. Now I think it's shrunk down to about 1 or 2%. And I'm just interested to know whether that's because of a lack of resources, a lack of enthusiasm, or is it just because people are complaining less about unauthorised adverts? Have people just become more accepting of roadside advertising? And given that we're a primarily complaint-driven function, is that the reason why we're not doing as much anymore? So that's really as much as I want to say. There's my final slide. I know it says I'm amazed you got planning permission rather than advertisement consent, but we'll just gloss over that. And now all I've got to do is to work out how to get out of the presentation and back into the webinar. So just bear with me. Did that work?
It did work. That's great.
Fantastic. Good.
All went very smoothly. Thank you. There's a couple of questions I've got, but we'll save them for the discussion section. So brilliant. Thanks for that, Mike. I'll bring you back very shortly once we've heard from the others.
That's great.
So, next, I'd like to just introduce Liam Jones. He's the team leader at Swansea Council, with responsibility for overseeing an area team covering development management, enforcement and appeals. and he was also previously the head of development management at Pembrokeshire Coast National Park Authority. Very nice part of the world. And Liam also sits on the NAPE Management Committee, and he's the representative for Wales. So I'll hand over now to you, Liam. Thanks.
Okay, thank you, Neil. Just get my presentation up. Okay, thank you. Yeah, in terms of myself, I have quite a background in enforcement. Been working in planning enforcement coming up 15 years. I'm a team leader currently in Swansea Council, so overseeing a team responsible for development management, appeals and enforcement. In terms of our legislation in Wales, we have 1992 advertisement regulations. Basically sets out what we can and can't do in terms of advertisement display. In terms of action and enforcement action, that could be pursued under section 224 of the Planning Act. It's separate to a breach of planning control in terms of unauthorised development. A breach of the regulations is pretty much a strict liability criminal offence. As Mike has touched on in terms of Scotland and the prosecution angle, normally in Wales I found we tended to use the prosecution aspect in taking a breach to the magistrates court. In terms of the considerations, we look at amenity and public safety, whilst some will cite other considerations and planning policy and decision making, it largely rests on those two issues. As said on the slide there, legislation also covers there's guidance in terms of TAN 7, quite dated now. 20 years ago that document was produced, and things have moved on quite a bit to the digital age. In terms of experiences, as I touched upon, I've been working in local authorities for 15 years. I've dealt with all types of complaints. This covered adverts, largely starting out as an officer in Glamorgan Council. My caseload was mixed with application and enforcement breaches, including adverts, and I've seen through a number of prosecutions while I was there. My experiences have been a bit more varied. I've tended to see that often in local authorities we're playing a reactive role to complaints rather than proactive. We have to, enforcement officers react to what comes in and finds a solution to either get the advertisement removed, deciding on the expediency of not taking any action. Regulations are quite complex, particularly where there's a large amount of signage is granted as deemed consent, so actually doesn't need permission of the local authority. I found a lot of the complaints get resolved informally by the owner. There's no need to take further action, or there's some form of negotiation to reduce the extent of signage. So really, you're left with cases where a small minority of cases then that you have to pursue a prosecution on. In terms of challenges, as touched upon there, the complexity of the regulations. Any officer or member looking at regulations can get confused by what is or isn't allowed. So it's one of those things look at a bit quite regularly as an officer. Get familiar with the different classes and what is or isn't allowed. As Mike touched on in his slides earlier, there are certain things in there where planning permission is deemed to be granted for something that is defined as an advert. You may need to look at other options such as discontinuance notice if you're going down the line of focusing against something that is deemed consent. So there is complexity there. Another thing I found, particularly as an officer, was people not taking you seriously on advertisement breaches. And what I mean by this, business owners, they've also not react to a letter received, or think, oh, it's an informal letter, park the issue, not do anything about it. But the implications are there, and the authority can prosecute. Often as a last resort. I think I've dealt with a number of cases. One stands out where a garage owner put a large hoarding sign up. I wrote to them. They didn't really take me seriously. worked up a witness statement with legal officers, and then they were on the phone then shortly after to ask us to stop the prosecution. So it can take a lot of work to get to that stage, but it is important to be clear on the prosecution side of it. Other challenges, investigation. I'd say it's really important to get extensive photos, measurements of the signs, make sure you're clear on what the breach is. It goes without saying really, but it's important when you come to prosecute someone that you have all that evidence, you have a full picture, and you've been to see the site before you take it forward as a prosecution. Very important. And transient and temporary adverts, particular challenge, because what I found is people obviously they take a sign down, but then another one goes back up, maybe by a different company. So you're often faced with an issue of trying to resolve that. I know in Swansea we've got issues with letting boards on HMOs, for example, so there are deep consents there. But it's the case of trying to find a way to tackle a problem. So in terms of time and resources, again, local authorities are stretched for resources, so they're dealing with complaints, but I'm sure authorities would like to do a lot more proactive work and tackle particular problems and areas. In terms of tactics that I've used personally, I don't think you could call it tactics, but it's really just knowing your facts, and as I touched upon then, getting your measurements, getting your photos for your visits, and speaking to the owners, setting out that position early on, explaining what would or wouldn't be acceptable, and having that sort of negotiation to come to a solution really for their business. I mean, given the COVID situation at the moment where businesses need to advertise, it's really important that we at least acknowledge that need and sort of help out as far as we can. I just put a couple of slides. I won't go into detail. I'm mindful of the time. This is an example in Swansea. An officer's noted a very garish illuminated sign at a restaurant. The owners were written to by the officer. Negotiation took place, and then the sign was removed, so it was positive. Another one here, prosecution. You can see moving illuminated sign at a barber's. Long-standing case. Letters didn't work in this instance, so the prosecution and the sign came down. Discontinuance notice, I mentioned it earlier. You can use these where there are deemed consent. And you can see this one had a particularly positive outcome. Informal letters didn't work. We had to take a formal approach really, and you can see we allowed them to keep the one main sign, and the rest of it was cleaned up, and they actually painted the building as well. So that was a positive. So just give a general flavour really. Thank you. At the end of my slides. Just find a way to come out to it.
Brilliant. That's great. Thank you, Liam. That was a good overview of what's going on over in Wales at the moment. I'd like to now bring in Chris Blair. He is been a planner since 2002, and he's currently planning enforcement manager at Ards and North Down Borough Council. And Chris is the Northern Irish representative on the NAPE Management Committee. So I'd like to hand over now to Chris.
Thanks very much, Neil. That's great. Yeah, I've had a lot of experience with signage over the last number of years. I've worked in planning enforcement at where I am currently, and also prior to that, before planning function moved to local councils, I worked in the central government and the DOE in the planning enforcement as well. So just quickly, I just want to run through a very short context in terms of Northern Ireland, and then pretty much some of the challenges that I think Northern Irish councils are facing in particular at this moment in time in relation to the unauthorised advertisements. So unauthorised signs and advertisements really do contribute to a significant number of cases in Northern Ireland in any given year. There's a broad range of advertisements that we would have to deal with, principally relating to businesses that have been erected along roadsides and any prominent position you can think of on buildings. Also, a major factor that has arisen in the last year or two has been the unauthorised erection of estate agent signs that have been erected along roadsides, and they're not in relation to the land that has been included in any sale. This is causing a real blight. There's a real proliferation of these types of signage. Other signs would be trailer signs. These are often difficult to prosecute against, as they can be moved quickly on from site to site. There's unauthorised hoardings, unauthorised LED screens, dealing with the erection of maybe multiple signs, multiple smaller signs on walls and fences, often causing visual cluttering. The primary legislation in Northern Ireland is the Planning Act for Northern Ireland 2011. And under Section 130 of that Act, it deals with the control of advertisements. And then one of the main functions that we have is being able to prosecute. It's a direct offence to erect a sign without any advertisement consent, and this is dealt with under Section 175 of the Act. And that is often really the case and the direction that we would go down in relation to if we're not unable to deal with unauthorised signs ourselves through works for the council, we will prosecute. And the maximum fine involved there is £2,500, with further daily fines of £250 for each day that the advertisement continues to be displayed. Obviously, we can prosecute again if those signs haven't been removed after they've been through court. If a sign's been erected for a period of 10 years, we are unable to take any form of enforcement action as it becomes immune. Also through our legislation, somebody can apply retrospectively to try and get any form of permission granted. But ultimately, just in terms of the challenges that we face in Northern Ireland, there's three in particular, I think, cause the fact that signs here are so difficult to potentially enforce. So first up is there's no real support through the courts. Fines are never really that big, even when we do prosecute. So we have to be absolutely certain that it's definitely worth our while proceeding to court. So there's a number of situations and scenarios that we have to take into account before we do so. Ultimately, is there a road safety issue? Is it a distraction to drivers, or does it have a significant adverse visual impact on the surrounding environment? Example, is there an impact on a conservation area, a listed building, area of township character? Does it cause visual cluttering, or does it result in a proliferation of signs in a particular area? So those are the sort of areas that we have to really consider and work through. And ultimately, we will try to resolve breaches of planning control in relation to advertisements ourselves by contacting and working directly with the owners of the sign, trying to get those removed. We will be writing to them. We'll be carrying out multiple site visits and just trying to first and foremost resolve those issues, because obviously money is a major aspect, especially when it doesn't come back through the courts. Secondly would be the lack of resources, and obviously I presume that's often the case for many people, but in relation to ourselves, particularly our time, our money, as has been indicated, and also just staffing and the amount of time that it takes to thoroughly investigate unauthorised advertisements is significant. So when enforcement teams don't have the staffing that is needed, and certainly at the moment with the ongoing COVID crisis, staffing is being redirected elsewhere. And finally, and one of the major problems is that we feel is that we don't have the power under our legislation to remove signs ourselves. it doesn't bring us along too well, especially when there's through the courts it isn't seen to be a major deterrent there. We can ask our neighbourhood environment teams to remove it under their legislation, but only if it's on council land that a sign has been erected. Otherwise, unfortunately, there's no real deterrent, and unless the courts continue to take a dimmer view of advertisements, I think it's a problem that certainly here in Northern Ireland we're going to face for some time in the future, dealing with unauthorised advertisements. As I say, in the particular moment, there's unauthorised estate agent signs, and there's hundreds of those that each council are having to deal with, and that is taking up a huge amount of time to try and chase those up and get those removed and the enforcement cases resolved. So those are just some of the issues that face Northern Ireland councils at the moment. So many thanks. That's me. I'll move back to Neill again.
That's great. Thank you very much, Chris. Very interesting insight to what's going on over in Northern Ireland at the moment. So thank you for that. I'm going to bring in now Dawn Russell, who heads up the 11-strong planning enforcement team at South Gloucestershire Council. And Dawn sits on the NAPE Management Committee as well, and she's the representative for the South West. Now, unfortunately, we're having a little bit of a technical issue with Dawn's camera, but she has managed to dial in. Hello, Dawn, are you there?
Hi, Neil, can you hear me?
I can, brilliant. So are you all right to carry on?
I can. Does this mean we get to watch you through my presentation? How does this work?
I think I'll turn my face off. I think it's probably better for everybody. Yes, thanks for that. And I'll hand over to Dawn now, who's just going to talk about advertisements and her experience of advertisements in England. So thanks, Dawn.
Thank you. Hi all, I hope you can still hear me. I'm really sorry for the lack of visual. In true local authority fashion, my laptop died just before needing to do this. So I'm gonna go through what I was going to discuss. I did have some visuals, and I know that adverts are going to be a little bit tricky without any visuals. But let's see how we go. I hope you can still hear me. Okay, so we were asked to think about our experiences with adverts, go through our main challenges and any tactics that we use and sort of, you know, dealing with adverts. Over here in South Gloss, we're half rural and half the suburbs of Bristol, and we have the M4, the M5 and the M32 running through our area. So our cases are pretty much reflective of that. So far in 2020, this might be an answer to a question that Mike raised earlier, we've only received 15 complaints about adverts, and this is 15 out of almost 800 complaints received this year, so it's only about 2% of our caseload. This number would suggest that enforcement is a lower advert enforcement is a lower priority for us, and in the main it's true. I suspect that the makeup of complaints received by us are very similar to the rest of the UK, and that they are a sign of the times and the result of how people are operating at present. Just as a sort of a quick explanation of the cases that we receive, we have major house builders putting up their adverts, we have the retail units advertising on their billboards with their illumination, we have a number on the motorway or on the roadside, we have a couple of pubs scattering their adverts over their buildings, desperately keeping the public interested. We have a number of people advertising their businesses of working from home on their properties. We have some on highway land, and we have some on listed buildings. As always, most of the complaints are the complainants are those that are directly affected. But as sort of half of the complaints about adverts we receive are from ward and parish councillors. So for us, political interest and involvement seems quite high for adverts. Looking at what the main challenges are, when I sort of thinking about this, I came up with 6 things, and I think they're kind of consistent with what's been said already. But considering the fact that 99% of all the adverts raised to us are illegal, it's actually very, very hard to achieve a good or a quick win on an advert, we find. You know, but taking into account that very few, you know, actually ever meet the deemed consent criteria or have any prior consent. In the past, we've had fun determining whether or not the display is actually an advert. A little while back, we had an individual that was enjoying decorating the side of his home. I can't actually show you it right now, but he was very politically minded, and the side of his home changed very regularly with his protest or his version of what he wanted to say. Looking through the legislation, we found it really hard to actually decipher, the purpose. Was it actually, what was it advertising? What was it announcing? What was it directing us to do? And so we had to spend a lot of time actually making it meet the criteria of an advert, even though, interest was high, and one of them actually referred to something that was really offending the public, and it was really highly politically interested. Another challenge that we face is sort of deciding whether or not to initiate prosecution proceedings against the landowner or the business being advertised, or both. Advice is usually to go for the landowner, as they have little defences. Usually they have less resources and are more likely to actually remove the display. However, in the majority of circumstances, logic would suggest that in going for the business being advertised, it would be a more clear lesson to them and likely or hopefully prevent further breaches occurring. But we find that businesses have more resource. They're prepared to wait for the delayed prosecution proceedings whilst they're still displaying their advert. And furthermore, when the costs and fines are awarded, magistrates don't see the significance of the breach. And certainly in our area, fines are usually low, and businesses consider them more as a bit of rent than an ongoing deterrent. And obviously, if the advert does get removed, we usually find that it pops up again nearby. I think someone's already gone through the fines and the levels that are available. We've also had cases where companies play the game by deferring to parent companies and saying they're not the person responsible, and using their legal teams to move us up the chain. That's also something that we have to deal with and can feel disproportionate to the breach. Often we wonder whether something like a fixed penalty type of approach might be more timely and more preventative, but obviously we wouldn't want one that stops them having to comply with the requirements thereafter. So that might be something to look into at one point. More recently, of note is a time limit of 6 months from obtaining evidence of the legal display. This is something that we've had to bear in mind at the moment, in view of the COVID situation, the delays in court, delays in our own processes, and it's just something that has become more prominent for us recently. Another challenge that we've thought about is dealing with the breach as a whole, I think, and we use the term best administrative course of action quite a lot, and often something that is a breach of planning control will also be an advert on the highway, where the Highways Act provides legislation. It does that for things on their land, and it also does that for things on the pavements, like A-boards. But we really find it difficult for other departments to recognise that power or to use that power, and often it will come straight back to us as the main port of call when our legislation isn't as direct. The last thing I put on there was something that we're having to consider at the moment, and I don't know whether we're alone or whether we are consistent with all other local authorities, and that is that we're having to become more business-like and to either earn income from our services or charge for costs incurred by our services. And for this reason, I find adverts becoming a bit more to the top of the charts for us in terms of the costs that can be brought forward for things like Section 225, removing and obliterating, or Section 225A about removal notices. Just because the fact that costs and are involved in that legislation makes them something that I'm now having to consider quite prominently as to whether this would be of any use to us. But I think this, for us, I don't know whether because we'd have to toe the line of reasonably incurred costs, I don't think it'd be a massive windfall. And also for us, it becomes a practical issue. I don't know whether we are alone in how we are set up. but you know, the practicalities of who actually removes the advert, who transports the advert, where is it stored, who takes the money when the costs are incurred, all of these things are things we're looking at the moment to become more business-like and make sure we're not you know, doing things for free. I was asked to sort of talk about any tactics we use. Honestly, our tactics are limited. I'm very happy to steal anyone's, you know, what anyone presents today as a tactic, really. But here in South Gloss, we run what's called a two-tier planning enforcement service. We have investigators that evidence all the allegations in the first 10 working days, and the officers that take on the cases that can't be immediately dealt with and require further work. Because of this team design, we find that because 99% of all the adverts fall into the same process, we've designed like a fast track system with standard letters that are used, mostly geared towards advising that displays are legal, explaining their options, strongly requiring the removal of display with an automatic revisit date scheduled for the investigators. And we find that this kind of is proportionate for us. There's a limited resource use because we know that we're saying the right things with a limited effort. And also, you know, we know we've started the right communication. Anything that's still there after that warning will then go on to an officer. So that's the tactic that we use. I suppose it's a collection of standard letters that we use. I did have an example to show, but I don't think it's going to be worthwhile doing it without a picture. So I might have to stop there if anyone can still hear me.
Yes, we can hear you. Thank you, Dawn.
It's the strangest thing. Sorry, presenting to nothing.
Yeah, it was very good. Thank you. So that was a really interesting insight into to how you're dealing with advertisements down in South Gloucestershire. So what I thought we'd do now is if we could bring back the other panelists, so if they want to switch their webcams back on. Dawn, if you wouldn't mind, just you're still there. We've got quite a number of questions. So what I'll do, I'll kind of I'll read them out and ask each of you to give the first answer, and then maybe if the others want to kind of chip in and have a discussion about where that answer goes. So let's just have a look. So I think this one, Dawn, you might be able to answer this one because I think you touched on it just now. So we have a question from Chris Briggs. He says there's an advert, if an advert is on a trailer located on the highway, is it a matter for the highway authority to remove?
I would argue that it is, providing it's on a structure specifically designed for the display, then it's an advert. And if it's on the highway, I would argue that the best way of getting rid of it is by using the highway powers to remove it.
And I think you said kind of highways were potentially a bit reluctant, or were thinking that it was actually a planning enforcement issue rather than theirs. Is that kind of quite common kickback to say, well, planning enforcement needs to deal with it, not us?
That's most certainly what we get. I don't know whether it's consistent everywhere else, but you know, I think with adverts being something that is not anyone's main priority potentially, I think we do struggle a bit with different teams trying to bat it around, and absolutely it's within our power. But obviously, as we know, our legislation requires lots of expediency judgments and justifications and timescales, and often it seems a little frustrating when you feel like there's another legislation that can deal with it direct.
Yeah, Mike, have you got something to add?
I was just going to say, I think, and I've had this experience with the roads authorities as well when I was doing the job, and something that Liam mentioned in his presentation. Whenever we're looking at adverts, we're looking at them either in respect of impact on amenity or impact on public safety. And public safety normally ends up being highway safety. Roads will always tackle an advert if there's a highway safety issue, but very rarely is that the concern that's driving it. It's normally an amenity issue that's driving it, and that's why it always ends up coming back to planning, because we tend to look at the amenity side of things more than the public safety side of things. Yeah,
that makes that makes sense. So next question. Sorry, I didn't go to the start of the list. So this question is from Debbie, and I guess this one would be directed at you in the first instance, Mike. Is the fact that in England we can only go to the magistrates court, Is that the only reason we do not have advertisement enforcement notices in England?
I genuinely don't know the answer to that. I mean, we have both options. Now, whether they gave us advert enforcement notices because of our difficulties getting a prosecution rather than the other way around, I don't know. But I always thought, and I think it was a missed opportunity when you were going through a lot of the new advert provisions that came in through the Localism Act. And I can remember discussing this at things before, is why didn't they give English and Welsh local planning authorities the ability to just serve a straightforward advert enforcement notice? But I don't know the answer to the question. We're just lucky up here in Scotland in that respect.
It would seem a very sensible solution compared to having to go to court, and I think in the current climate, courts, you know, just absolutely blocked up for months, well into next year. I can kind of see magistrates' faces when, you know, in a year and a half's time they're presented with an advertisement kind of prosecution case. So it would seem to me that it's certainly something that could or should be potentially rolled out across all the home nations and not just Scotland. It always seems strange to me that you would, you know, something as pretty straightforward and simple as a small advert, you could be prosecuted potentially, whereas, you know, you could do lots of other horrendous unauthorized developments and, you know, have to go through the whole process of, you know, serving enforcement notice, appealing, compliance. So that's certainly an interesting case, and I wasn't actually aware that Scotland had that power. So that's very interesting, and I hope sort of everybody else in the home nations who doesn't have that power might give some thought to potentially bringing that up in a response to the current white paper for stronger planning enforcement powers. I know that's just for England, so certainly that's something that we might want to mention as NAPE. Another question we have, there's a few comments and I'll kind of get to them as well, but the next one is what are the panel's opinions on banners, etc., that make political or religious statements but don't actually try to sell, announce or direct anything? Are these still signs? Liam, do you want to have a go at this one?
I'm trying to remember what the definition is of an advert, because if it's making a religious claim,
is it still advertising the church as such?
I think it's an announcement.
Okay.
Yeah.
So it comes within the definition.
yeah, there's class 2, I think, in our regs deals with religious, educational, cultural, recreational displays. But yes, it is an announcement, really, isn't it?
Okay. Yeah,
I think
so
one of the issues we always had was whether these big banners came within the definition of a poster and a placard. And we always considered that they did. We took legal advice. And so we would quite happily take them down under the Section 225 powers, because they're very rarely on the land to which they relate.
okay, that question was from Kathy McCurry. So thank you for that one, Kathy. This question's from Debbie. In response to Mike's point about why the number of cases investigated has dwindled, it seemed to be a case of both less complaints and lack of resources, which I think all the panelists have kind of touched on. And certainly the enforcement officers where she is feel that in fact the city council is one of the worst offenders in any case, and it's a bit embarrassing having to I'm guessing take action against other people when obviously the council were at it. And certainly where you walk around anywhere now and roundabouts and signage, there's always banner posters up from the council, you know, advertising various bits and bobs. And I'm pretty sure consent hasn't been or sought for any of those. Does any of the panelists have any kind of comments on councils being their own worst enemy in this case?
Yeah, I mean, we find in Swansea, I mean, the different departments will ask us the question, do you need permission for these signs? And then we give our view. I mean, we do have difficulty as well with obviously council is a big entity and you have other departments responsible for land. So you might have cases. I know we've got a current case where got council land and a fine has gone up on it by the community council, who's saying that the council has given authority for it to go up. So, there are differences obviously across departments. It's having that ability to say whether something needs permission or not. And I know in Wales we don't have a formal mechanism for giving an opinion on whether something needs consent. So I know that review of planning law is looking at that, potentially bringing it in the future, where like planning applications you get a certificate of lawfulness. That might be an option in the future.
Okay, that's great, Liam. Thank you for that one. I've got another question here, and so this is from Darren Hobson. It says, at Test Valley, we receive a fair amount of unauthorised adverts. However, we're currently having a little battle with estate agent signs. These are covered by Class 3A of the regs, but we are finding that an officer goes out and requests their removal under Section 225, and they comply, but they keep coming back. What advice can you give? We are looking at 3 strikes and you're out option. Dawn, do you want to go forward on that one? And then maybe Chris could chip in afterwards, because I know you talked a lot about estate agents, but being in England. Dawn, do you have something to...
Yeah, I mean, we a little while back had a similar thing. I don't disagree with the 3 strikes and you're out rule. I think that's possibly fair. We also tried a tactic of scattergunning a letter to all of the estate agents in the area, because what we didn't want is they were sort of arguing that one was allowed to do it and one wasn't, and so we tried to sort of do it as a blanket approach, really, just to prevent any argument that we were being unfavourable or unfair. So that's kind of how we approached it previously.
Well, we did actually the same as Dawn. We actually tried to resolve by issuing warning letters initially, individually, to each breach. However, that didn't really work, and any time the sign came down, others went back up pretty quickly afterwards. So we also issued a blanket letter across the district to all estate agents, but pretty much stated in that if the signs weren't down by a particular date, we would be taking them all to court. And also within the letter indicated that should any further signs go up in the future, we wouldn't be contacting them again, we wouldn't be issuing any further letters, and we would just proceed. If we found them, we'd be proceeding directly to court. So that actually is a number of signs were, and a number of estate agents were on their way to court, but unfortunately then lockdown hit and it hasn't proceeded any further. But ultimately, that's the position we're in. So if it continues to be a problem once everything is settled down, that's the course of action we'll be taking. So I think it's probably the best way and means possible to probably deal with the blight that estate agent signs are on our streets.
Yeah, one thing I'd noticed sort of when all the pandemic hit and kind of after that, was quite a lot of estate agent boards started popping up thanking the NHS. I don't know if anybody else has kind of experienced that. I know estate agents are always quick to jump on the sort of school fairs and kind of stuff like that, but certainly in parts of London there was a massive proliferation of estate agents with kind of the thanking the NHS, and I know a lot of boroughs tried to kind of tackle it, but it was quite a contentious issue, because the estate agents would be, we make a small donation to the NHS for every sign we put up, and yeah, it was a difficult one for local councils to kind of deal with. Obviously, in the short term, it wasn't too much of an issue, but certainly leaving them out longer term. Have any of the panelists kind of had to deal with that?
Yeah, I mean,
Yeah,
in Swansea, we've got letting board issues throughout, particularly with HMOs, similar to Chris there, and in terms of the fact that they go up, the officer investigates, they get taken down, and then you've got issue happens again. We have in Swansea, a good few years back, had a voluntary code for this type of thing. But I mean, that's fallen by the wayside in a way now, and we're looking at whether we can use, I think it's Regulation 7 of the 92 regs, so we can remove the deemed consent for letting boards. So we're currently exploring that, but we have to have evidence that there is harm. So we're obviously investigating and keeping a record of what the issues are locally. I think Cardiff might have had a Regulation 7. Looking at that really.
Okay, Dawn, sorry, did you want to come in on that as well?
Yeah, I was just going to say that we didn't have the NHS, but we've certainly had people joining on to schools and events at schools. And I suppose that makes it a very difficult one in terms of enforcement. And we just took, I suppose, a realistic view and said, okay, you're advertising this event, you've got a certain period of time, then it's coming down. So, you know, we try to be reasonable, I suppose.
Okay, thank you, Dawn, thank you, Liam. So next question we have from Lee Douglas, and I'll direct this one in the first instance to Mike. What do we think about serving enforcement notices against unauthorised advertisements displayed on buildings where there could be a material change of use of that part of the building as set out in section 55(5) of the Act, Town and Country Planning Act?
Yeah, and absolutely, that is one of the options that's open to you, because you don't have the specific advert enforcement notice like we do in Scotland. Then you can use the fact that section 55 states that using the outside of a building for purposes of displaying an advert will always be regarded to be a material change of use of that part of the building. So in those circumstances, there's no reason why you couldn't go down the straightforward enforcement notice route. Similarly, with trailer backs in fields, there's no reason why you couldn't just go for a change of use of land enforcement notice to a mixed use. Let's say they've still got the sheep in the fields going round the trailers. Why not just go for a mixed use of agriculture and the siting of trailers for the purposes of advertising? So there are all, you know, other ways of tackling it. Other people have mentioned do it through the Roads Acts because they've got good powers. Somebody else mentioned looking at community protection notices. So there's all sorts of different ways to skin the proverbial cat.
Excellent, that's a great answer. Thank you, Mike. We've got a comment from Craig. Hi, Craig. Craig sits on the NAPE Management Committee as well as the representative for Scotland. And he says, in terms of Mike's question, considering the scale of signage in the city, it's very much underreported. He says 25 inquiries only so far this year, and proactive monitoring of sensitive locations in the city where there is a concentration of unauthorised signage. This is something that they aspire to do. However, frustratingly, in Edinburgh, resources are being significantly pulled by the problem of Airbnb investigations, which is impacting on their proactive work. Yes, yeah, it comes down to resources again, isn't it? It's kind of where they're best directed to. I mean, I guess if you've got a city such as Edinburgh, where there's going to be conservation areas, listed buildings, you know, basically encompassing most of the centre of the city at least. That it's just a balancing act, isn't it? I guess between where you direct your resources to, and it kind of seems that advertisements sometimes are pushed down that kind of that league of what's important to the teams or not. But I guess it depends on like Edinburgh. I guess there would be more of a need, whereas some other places, you know, it's not so much of an issue. I think we've probably got time for one more question, and I think from Charlotte Mewburn, and I think we might have answered this, but would you expect highways or planning enforcement to deal with estate agent signs erected on road name signs? Chris, I know you talked about estate agents board by roads. Is that something that you deal with, or would it be the Highways Authority?
Well, really, in terms of most of the signs that they've been and that we've dealt with, they're either probably attached to walls at the junction of roads or on the main roads at the side of the roads themselves. So we've, in terms of state agent signs, we have just tried to get them removed ourselves. There are occasions where if you use the road service here in Northern Ireland DFI roads to try and remove signage, but it's ultimately really on a case-by-case basis, and maybe particularly if it's on maybe road service property, we might use them to try and get it removed. That's as I can offer.
Okay, so I think probably have got time for one more question this time. So this comes from Mark Tansley, and he says, does no one else use removal notices under section 225? So has anyone got any experience of using that power? Dawn, do you want to take that one in the first instance?
I was just thinking, I'm assuming we're talking about the structures 225A, or but we haven't actually used it because we always tend to go for prosecution. And as I say, you know, we are currently looking at being more proactive and taking action more directly and actually removing things, but that's becoming sort of more of a practical decision as to how we deal with those, you know, who takes them, where do you put them. So I really appreciate anyone that's got experience of that, but we don't at present.
Mike, have you any experience of removal notices?
I'll switch this back on, but my phone's ringing and I can't reach over to switch it off. It's probably only somebody trying to sell me PPI anyway. Yeah, both in England and in Scotland, we used to use the posters placards removal notices quite a lot. It's section 187 up here. It's a great tool. It's dead effective. It allows you to take action pretty quickly. We had similar powers under the Ards Cumbria Act of 1982 that allowed us to do the same thing purely in Cumbria. And I always thought it was a really, really useful tool that should be used a lot more often.
Yeah, it sounds as if that would be kind of the most direct way of dealing with it, but only inappropriate in circumstances where it would, you know, it's not can't use it in every circumstance to do with advertisements. So that's great. So I think that probably brings us to the end of the session quite nicely on that note. So I'd like to thank you all for attending, and special thanks to Dawn, Mike, Chris, and Liam for joining us today and talking about the subject of enforcement around adverts. We've got plenty of more sessions coming up this week, so I hope you'll be joining us for those. But for now, I'd like to say thank you very much for joining us, and hopefully see you later on in the week. Thank you very much.